Hi, students. I'm back again. This is Unit 10. Unit 10 corresponds to Chapter 10. It's the last chapter, last unit of the class. This is week 18, which is actually the last week of class. Unit 10 is on constitutional and civil rights in the government workplace. And this week, week 18, focuses on employment discrimination. So the Federal Equal Employment Opportunity Act prohibits discrimination based on race, color, religion, gender, and national origin. And there's basically three types of discrimination covered by this federal statute. One is disparate treatment. Secondly is disparate impact. And then lastly is harassment. So let's get into these three types of discrimination. And all of these are prohibited by law. So the first one, disparate treatment, um, is pretty simple. All it means is that an employer is treating a person, um, the person is an employee. So the employer is treating an employee differently than somebody else based on that person's race, color, religion, gender, national origin. And you simply cannot do that. So, for example, someone has a hatred towards blacks, and there's a black employee, and because the person is black and they don't like blacks, and they tell that person or assign that person to working graveyard for the foreseeable future. So they're treating that person differently, rather punitively, based on their color, and that is unlawful. That's disparate treatment. That's a pretty simple thing to understand, I think. Let's talk about the second type, which is disparate impact. That occurs when an employer uses a selection criteria that disproportionately eliminates members of the protected class without being a valid prediction um, of the knowledge, skill, and aptitude needed for that particular job. So, what does that mean exactly? So, let me give you some examples. I think it will be helpful to understand this. There's a case called Griggs. They gave an aptitude test, and they gave the aptitude test to people applying for a job. And the result of that eliminated black applicants. And this was found to be unlawful because there was no correlation between the test and the knowledge, skill, and aptitude required for this particular job. So they could not link the test and the requirements for the job. They could not make a link there, and it had an impact on black applicants. Let me give you another example. Let's say they have a height and weight requirement, maybe even a strength and agility requirement for to be a correctional officer. So, and these requirements, basically, when you look at it on the face, they appear to be neutral. They do not appear to discriminate against anybody. But when you look at the statistical analysis, it shows that most women are disqualified. This is just an example. So in order for these requirements to be valid, they have to connect the height, weight, strength, and agility requirement directly to the job. If they're not able to do that, then that is unlawful. So they have to be able to connect that to the requirements for the job. That was the case in Dothard. In fact, it was a height weight requirement. She was 5'2", 120 pounds, and she did not meet the requirement. And so she was eliminated as she filed a lawsuit based on disparate impact discrimination, and she won. Why? Because the employer could not show that um, the a correctional officer had to be over that height and over that weight. So they could not link up the requirement to the requirements for the job. And then the third type is workplace harassment. So there's a couple of types. There's one that we refer to as quid pro quo, which is a Latin term that means this for that. Basically, it means an exchange. And in the employment context, it means where an employer either threatens negative action against the employee or withholds positive action unless the employee agrees to sexual demands. So, for example, the employer will say it's a supervisor goes to an employee and demands some sort of sexual act, and the employee declines to participate, and then the employer takes some sort of negative action. For example, having them work graveyard, having them work at a great distance from their home. Um, you know, maybe there's a certain job assignment that isn't particularly gratifying, but they impose some sort of negative action or threaten negative action in order to get that person to perform that sexual activity, and that's unlawful. The other one I mentioned was withholding positive action. And as an example of that, they tell them that, hey, you're not going to get the promotion unless you participate in my sexual demands. And that is unlawful as well. That's called quid pro quo, meaning this for that. And it's an exchange. The other type of workplace harassment is what they refer to as hostile work environment. It includes race, color, religion, national origin, um, or sexual orientation. Um, it includes unwelcome sexual behavior so pervasive that it alters conditions of employment and creates a hostile work environment. So, so what factors does the court look at? Well, they'll look at verbal types of harassment, physical harassment, threatening type of conduct, humiliating the employee. They'll look at the frequency of it. Does it happen all the time? Does it happen one time? Because it has to be pervasive. You know, if it's one time, it's not going to satisfy this law. But if it's pervasive, if it's every day or every shift, something like that, then it is pervasive. They're looking at how frequent it happens. They're going to look at coworker and supervisor participation in the harassment. They'll look at did other people join in? Did this interfere with the work of the employee? Um, they'll look at what kind of comments were made. Were they sexual jokes, obscene graffiti? But it has to include race, color, religion, national origin. Um, it's unwelcome sexual behavior so perverse that it alters conditions of employment, creates a hostile work environment. So instead of unwelcome sexual behavior, it could be unwelcome behavior that targets a person because of their race, their color, their religion, their national origin, but it also includes unwelcome sexual behavior. I just want to be clear about that. So it might be, for example, if it's not sexual in nature, it might be verbal harassment of a person of color. So, for example, they're referring to a black employee by the N word. They threaten the black employee. They're humiliating the black employee. How could they humiliate? Maybe they put things on the person's locker at work or in their work truck at work. So they humiliate them, and they do this day in and day out, and everyone's participating in that. That would be a hostile work environment. Who's going to be liable for this type of discrimination? It's going to be the person who actually does it. That's for all of us, disparate treatment, disparate impact, and workplace harassment. It's the person who does it, but it also can include the supervisor, and it can also include the coworker, anybody that participates in it, and it can include the employer. The employer will be liable if the supervisor was aware of this and did not do anything to stop it, because the supervisor is part of the administration of the government employer. So anyway, I want to move on from this federal law to the Equal Protection Clause. And remember, under the Equal Protection Clause, persons have to be treated equally. That was the Yick Woo case that we learned about. And in the employment context, employment decisions have to be based on qualifications rather than race or gender. There's one exception, and that's affirmative action. Affirmative action is allowed to remedy an imbalance caused by prior discriminatory practice or to increase diversity to operate the government employer, the government agency more effectively, more efficiently. And then the affirmative action program has to be narrowly tailored to minimize the harm to those that do not benefit from the affirmative action program. So how do they narrowly tailor? The department must explore race-neutral alternatives. They must have a flexible plan that creates a preference for certain employees, not a quota. And you can't take away a job from a person who has it, already has it. And then the plan has to be capable of being reviewed. It's not an ad hoc, on the fly, seat of your pants program. There has to be structure, there has to be policy, and there have to be parameters set. So let me give you an example. In the fire departments and police department in San Francisco, and this is years past, the firefighters and police officers primarily were white, and they were male. And so San Francisco, well, the white males on the police department and the fire department did not reflect the diversity of the San Francisco community. San Francisco was and is more diverse than that. And so they needed to change the diversity of the police department and the fire department. So they created an affirmative action program to do that. And what they did is they wanted to target minorities for employment. So they created a recruitment process to, first of all, recruit them. Then they created a way to provide training so they could be successful in the application and testing process. Once they were tested, they were placed on a list, and then they could hire from that list. And if you see the results of that today, is you have very diverse police department in San Francisco, very diverse fire department in San Francisco. And the reason for that was affirmative action. That has taken place in agencies all over, the ones I'm familiar with in California, honestly. I think today you don't see that as a problem as you used to back in the time period I'm talking about would be the 60s, maybe some in the 70s, that time frame. But since then, I don't think you see as a big a problem as you did then. So I want to move on to another area, and that's called constitutional accountability. It's civil liability for a law enforcement officer when he violates a person's constitutional rights. So first of all, there's a U.S. code. It's Title 42 U.S. Code, Section 1983. So if you found a set of U.S. codes, United States codes, you went to Title 42. It's right on the edge of the book, and then you looked up Section 1983. That's how you would find it, and it holds this statute holds that a police officer is liable if the officer is acting under the color of state law and deprives an individual of a clearly established constitutional right. Now, when I'm talking about a color of state law, I mean that the officer is a state law enforcement officer. They work for the state. They work for a local agency, police or sheriff. This statute does not apply to federal law enforcement officers. The federal law enforcement officers can be sued, but not under this particular statute. They're sued under a case called Bivens, Bivens. Um, it's basically the same thing. It's just a different authority that's required for a federal agency than a state law enforcement officer. I'll give you an example. I just read about a case where a correctional officer, who is a local officer, put an inmate in a cell that was already covered with feces. Why did the officer do that? To punish the person that they put in there. And so that officer was acting under the color of state law, and the officer deprived this individual of a clearly established constitutional right, and that is the right under the Eighth Amendment to be free from cruel and unusual punishment. So that is a new case. It just came out. I just read about it, and the court said that this was a violation of this particular statute. So who's going to be held liable? Well, first of all, it's the police officer or local officer that commits the illegal act. So it could be an illegal search, for example. That would be an illegal arrest under the Fourth Amendment. It could be where you arrest somebody and for speaking when they had a right to free speech. So not only did you make an illegal arrest under the Fourth Amendment, you violated their First Amendment constitutional right to free speech. So you could be sued under two different theories. So usually those are the and then also, of course, the Eighth Amendment, cruel and unusual punishment. Those are the big areas I think for this kind of lawsuit. I was involved in one myself where I arrested an individual, and he ended up taking his own life, and I was sued under this for a violation of his Fourth Amendment rights, an illegal arrest. They accused me of taking his life, which was the wrongful use of force. Actually, they accused me of murdering this kid, which I didn't. And anyway, I was sued. It went to court. I went to trial. And after the plaintiff representing the kid rested, then the trial judge dismissed me out of the case and held that I was not responsible for what this kid did. He took his own life. So the officer can be, the supervisor of the officer can be. If, for example, if the supervisor tells the officer to arrest somebody, and it's an illegal arrest, then the supervisor can be held liable. The supervisor can be held liable if the supervisor was negligent in supervising the officer. Um, and then the agency itself can be also sued as well. Um, for example, they can be sued if there's some sort of official policy and custom and practice that leads to the violation of a person's constitutional rights. So let's say up in Portland and Seattle, where all this unrest is going on, and the administration, meaning the chief, captains, lieutenants get together and they basically put out a policy that you're to arrest anybody that's there. And, even a person that is there unknowingly that there's a protest, or he's there but not doing anything wrong, but their orders are to arrest everybody, they arrest them, then the agency can be held liable for that. Also, negligent hiring, if the agency hires somebody and they don't do a proper testing, they don't do a proper background check, a medical check, mental health check, physical agility check. I mean, and let's say they hire somebody who has a history of violence, and they did not do a thorough background. It was readily available information, but they missed it. They hired this person, and this person then went out and injured somebody. Then the agency could be held responsible. Also, negligent supervision, I already mentioned. Let's say that they do hire somebody and he's on the job, and this person um, has experienced some problems in his personal life, has become mentally unstable, alcoholic, a lot of drinking, a lot of drugs, and they just fail to supervise him. They're aware of it, but they don't do much about it. And he's out there. This person, as an example, as a police officer, is carrying a gun, responding to calls, and then all of a sudden, something happens and he's triggered and he causes injury to somebody, then the agency could be held responsible for that. And then also negligent training. As an example, let's say they give some new weapons to an officer, but they don't train that officer. For example, tasers are popular. I didn't have a taser when I was a police officer, but when tasers first came out, I don't know how much training they received. There were two cases, actually. One occurred in Madera, one in by Bay Area Rapid Transit, BART police. And what happened is there was somebody that was being combative, and in each case, the officer thought they were grabbing their taser, but they did not grab their taser. They grabbed their handgun and shot and killed the person. Now, the officers thought it was the taser, but when it was a handgun. So that was a situation of negligent training. You have to, when you introduce a new weapon, you have to make sure that the officer's familiar with that weapon, the way they carry it, the way it looks and it feels, because the early tasers were very similar in shape and size to their firearm, and it could be easily confused. So now they're smaller, and they wear them on the opposite side of their firearm. So they did all that to eliminate confusion from the officers when they decide to deploy a taser. So that was a type of negligent training. So Anyway, those are the topics that are covered in the last part of chapter 10. You're going to watch the video, this video, lecture video. I don't think I have another video. And then you'll be taking your test. It's on chapters 9 and 10, and that's the last test. And then you'll have finished the class. So anyway, I hope you're doing well. I'm sure you're tired of COVID, so am I. I think we all are. It's been a long time, and it's still going on. And this is middle of November. So I hope you're doing well. I want you to stay healthy and keep working hard at school and make good decisions for yourself. If you need something, contact me. I'm here. You know how to do that. I try to respond as quickly as I can, but I get busy too. And then once you're done, I'll grade your test and grade you for the class, issue the grades, and but that won't be today's middle of November, so this will be after the class ends in December. So anyway, I will end it and I will let you go, and I will hopefully talk to you soon. Okay, bye.